minutes, then we'll come back, provide the deliberation, award the prizes, etc., and then we'll go downstairs to the Japanese room for beer and skittles afterwards. So let me first of all introduce our bench. The Lord High Executioner is Phil Nolan, well known to the students and probably most of the professionals here. The two valuers are firstly Chris Torr, on speaking to the audience on your right, Chris Torr from Urbis, a director of Urbis, a leading firm of property consultants, and Gavin Burke here, who is a director of M3 Property Strategies, also a leading firm of property consultants. They are the valuer members of the bench, and then of course you know your fellow students, again on the right Simon Carter, and on the left Benjamin Lynn, who make up the total of the bench. So I'll vaguely describe what will be happening this afternoon. There is a timetable in front of you and we'll do our best to keep to it. Now let me introduce Paul Healy of the RICS to say a few words from their point of view, and that's all we'll hear from them. Thanks, Paul.
Thank you, John. Well, good afternoon, everyone. Welcome to this very, what I hope you'll find stimulating afternoon. Just a couple of words about the RICS. The RICS is the world's leading organisation for professionals involved in property, with over 110,000 members in 120 countries and over 50 national associations or local groups. It has offices in London, Brussels, New York, Hong Kong and Sydney. The Victorian and Tasmanian branch is hosting today, and we're providing the prize money. We hope you'll find it useful. Debate hard and passionately. When I was a student, cash was always very useful, so there are prizes there for you. I'd just like to reiterate John's words of thanks to the bench, to Philip, Christopher and Gavin. Thank you very much for giving up your time this afternoon as professionals. It's very much appreciated. I'd also like to thank Professor John Robinson and Richard Reid for your time in organising this. And also I'd like to thank my fellow committee members, Philip Lees and Andy Bendell, who've also been very involved in putting this together. So that's all I'd like to say. I look forward to a healthy afternoon's debate. Thank you.
This is a matter of Jones Proprietary Limited and Big Roads being the acquiring authority. You're all aware of the proceedings as they will take place in this tribunal, having appeared here on a number of occasions previously. I will ask you to keep to the very strict times allocated. If not, you will be removed from the room, forcefully if necessary. Having said that, this is a very informal tribunal, but I would ask that you adhere to those rules of evidence which you were aware of, and also in relation to parties being sworn in and sworn out if necessary. And having said those few opening comments, I may now ask the applicant, the claimant in this matter, Jones Proprietary Limited, Mr. Ellis as its senior counsel to commence your opening address. Mr. Ellis.
Thank you, Mark. Before I go any further, I'd just like to first submit a claim for additional costs for litigation to my client.
I'll take that on notice, Mr. Ellis.
No problem. This case is based on a compensation claim. The governing authority, to my left, and my client, their claims differ. Their claims differ by $308,515. Why? Why do you ask this? Well, we're going to tell you. On the basis of market value, disturbance, severance, injurious affection, my client's case is incredibly solid. The defendant's, on the other hand, is not. In addition to mentioned heads of claim, the dagger will be driven deep into the hearts of the defendants, based on other arguments such as capitalisation, interest and contamination. With this, my client's claim will be proved worthy. Thank you.
To complete your opening address, Mr. Ellis.
Yes.
Thank you for your delivery. You may move to call your first witness.
Thank you. I'd like to call my first witness to the stand, Mr. Stephen Warford. Please state your name, occupation, occupation and residence.
May I start, Mr. Ellis, with taking the oath first? We don't want him to lie about that.
Sorry, could you please, please place your hand on your hand.
I promise to tell the truth, the whole truth, and nothing but the truth, so help me God.
Your name, occupation and residence.
Name Stephen Walford. Profession, valuer. And I live in Mrs. Charles Street, Heidelberg.
Sensational, let's not muck about now. Mr. Lawford, how much land has been resumed by the MRA?
1,000 square metres.
How do you calculate the market value of this particular land?
Well, there's the agreed value of $75 a square metre. 1,000 square metres comes to $75,000. Valuation is made in accordance with the Spencer principle.
So the market value of the land in this case is?
$75,000.
Mr. Lawford, could you please define disturbance for you, being an expert witness that you are?
I go by a definition that was upheld in the case of Harvey versus Crawley Development Corporation 1957, which basically states that disturbance is any loss sustained by a dispossessed owner which flows from compulsory acquisition, provided that it is firstly not too remote, and secondly that is a natural and reasonable consequence of the resumption.
Therefore, what can be claimed under disturbance in this particular case?
$25,000 valuation fees and $2,000 legal fees.
Let it be known to the court my client has claimed, in addition to today's claims, $25,000 in valuation fees and $2,000 in legal fees from our reports. Mr. Lawford, could you please go further and define severance for us?
Severance occurs when only part of a property is compulsorily acquired. It is the depreciation or enhancement in the value, the retained portion of the land resulting from a reduction in area or its division into parts. That definition is upheld in Adelaide Fruit and Produce Exchange Code of Adelaide City Corporation.
Very insightful. How has this been reached in my client's claim?
By using a before and after method of valuation, this approach has been successfully applied in the case Gosford Shire Council in Green in 1960. The precedent suggests that in the majority of cases it is appropriate to use a before and after method of valuation when determining compensation for severance.
Excellent. Just to paint a further picture for my client's case, would you be so kind as to describe what you would state as injurious affection to the corporate case?
Define using the Morrison principle, which is established in Cornwall versus the Morrison case 1972. It is depreciation in value to the owner that results from the purpose of the scheme of resumption. It occurs only when the land has been severed and relates to the future or intended use of the land acquired and land used for that same purpose.
Therefore, Mr. Lawford, would you say that injurious affection is relevant to my client's claim?
Well, there is a loss of value to the owner in such that the stage 2 option could not be built to its requirements once the land had been severed. Basically, the limited access requirement, limited access road reduces the value and the potential of land to the owner because they can't get access from that side, and pretty much null and voids the option to build stage 2.
So, Mr. Lawford, you mentioned stage 2. Why would you take this into consideration and exercise this?
Well, stage 2 is the main point of contention because that's what's creating the fact that that can't go ahead is because the injurious affection claim that we made.
Fine. If I can just get you to refer back to Gosford Shire versus Green, that particular case, you mentioned injurious affection. How does this apply to injurious affection for our case?
That method of before and after can also be used to determine the injurious affection, the amount for it to be claimed for injurious affection, before and after method of valuing the property.
Self-explanatory, really, isn't it?